Pro-life talk. Real world answers. This is Life Report.
Welcome to Life Report. I'm your host, Josh Brom, and I'm here with my good friends John Gerardi, the associate at Egan, Flanagan & Cohen, back on again, as well as Jonathan Keller, the executive director of California Family Council, which you can check out at californiafamily.org. We are here to talk about the Hobby Lobby case. The oral arguments have just happened as of this taping, and a lot of people are a little bit confused about exactly what's been going on. I, for one, listened to the oral arguments and had a hard time following all the acronyms and everything, so this is one of those times where I'm not an expert on what we're talking about, but I'm glad to have friends who are experts so that I can learn as well as our audience. So let me just start with this question, and I'll pitch this to John Gerardi first. Where are we in this case right now? How did we wind up here?
Okay, so this case has gone sort of up through the federal courts. It started with a district court decision in the Western District of Oklahoma, which ruled against Hobby Lobby, saying that they can't assert a First Amendment freedom of religion claim because they're claiming that the government is forcing them to do something against their religious beliefs, and that they as a corporation have a right to free exercise of religion. Western District of Oklahoma didn't buy that. Then it went to the 10th Circuit Court of Appeals, so the next level up in the federal court system, which said, no, you do have a right to, your corporation, your for-profit corporation does have a right to free practice of your religion. And now that has been appealed up to the Supreme Court, where it's going to be kind of finally decided. So,
what are the main issues that the court has to look at?
The most important issue is whether a for-profit corporation, so we're not talking about nonprofit corporations, we're not talking about individual persons, for-profit corporation with shareholders and all that jazz, whether they can exercise a right to freedom of religion. And the statute that sort of governs this is called the Religious Freedom Restoration Act. And this was a bill that was passed in 1993 under President Clinton. And basically what it does is when government action forces people to do things that are opposed to their religious views, it puts basically a higher standard of proof on the government to justify why it's doing this, a higher standard of proof than the First Amendment alone requires. So imagine the Religious Freedom Restoration Act. It's like a little add-on to the First Amendment that's actually more strict, more strenuous. So the government would have to show, if there's burdening someone's exercise of religion in some way, they would have to show a compelling state interest and that they're using the most narrowly tailored means possible for achieving that interest. And so the big issue here is, okay, individuals definitely have this protection under the Religious Freedom Restoration Act. Nonprofit corporations do. Do for-profit corporations like Hobby Lobby, do they have that kind of right? That's really the central question to this whole thing.
I also do think it's important to point out, just on the issue of RFRA, which is the acronym. If you're listening to the oral arguments, RFRA stands for RFRA, Religious Freedom Restoration Act. That's what they're talking about. A lot of times there was a state version of RFRA that was actually attempted to be passed, or it was passed in Arizona a few weeks ago. It was vetoed by Governor Jan Brewer. If any of you followed that information, that case a couple of weeks ago, John, I'm sure you did, the media ruckus that was being made, literally you had people that were saying these are new Jim Crow laws that would be advocated against people of whether they were people that were gay or other people. It would allow discrimination to go into a place that has never been before. Ironically, this is just the same version of the federal RFRA that was passed. And unlike Obamacare, which passed literally by the narrowest of margins with not a single Republican voting, John, I don't know if you have the official numbers, but what I read was that in both houses of Congress, I think RFRA got a total of 4 no votes.
Yeah, it was something like that. It was sort of unanimously passed.
And signed by President Clinton.
Yeah.
So it's not like this is a crazy wacko right-wing law that Hobby Lobby is appealing to.
No, it is a little. The only thing that's a little different is now the attempt to have it be applied to for-profit corporations, which is a little different. But yeah, it was a very non-controversial law, and I think in a time when gay marriage wasn't as big of an issue, it was certainly not as controversial. Now it kind of is, because.
So let me ask you a question about that, or ask you both a question about this. When there's this idea that a corporation should be considered a person, there's kind of this idea that if you do that, then it's going to, it kind of just protects the rich or the top 1%, and it helps them just to get richer and be more protected. Like, no, persons are persons and corporations are corporations. And I just kind of want to hear that's a huge part of this case. So I just want to hear both of you give your kind of perspectives on that issue.
Right. Well, from the legal perspective, there's nothing novel or new or weird about corporations being people. Corporations, that's what a corporation is. It's this kind of legal fiction that a corporation is a kind of legal person that stands as a proxy for the incorporators and for the shareholders. It encourages people to get into business, because then shareholders are only going to be for corporate debts and for corporate liabilities, shareholders are only going to be liable to the extent that they've invested in it. So it's a really important mechanism for individuals to enter into the marketplace, to enter into commerce, and to interact. The other thing is that I think when young people think of corporations, I mean, they think of, Walmart and General Electric and huge corporations. A lot of corporations are very small. They can be small. I mean, the vast majority of them are small businesses. Mm-hmm. Businesses that have a couple of shareholders. Mom and dad and the son or whatever. So really, my contention has been, when you say that corporations don't have a right to free exercise of religion, when they have other rights, like they can be considered by the government to have a race. Corporations can be considered to have a race based on, for the purposes of certain affirmative action programs, based on how their shareholder, the racial makeup of their shareholders. They can express, they have freedom of speech rights. So there are all these ways in which we treat corporations as if they are persons, but in this case, no. We don't want to give corporations the right to free exercise of religion. Really, I think it's just inhibiting the rights of people, the people who constitute the corporation, who constitute its shareholders.
Well, and I also think, like John was saying, I think that there's a lot of kind of a double standard here. When you look at the fact that it's very convenient when you don't like either the speech that the corporation is promoting or the religious or moral beliefs that the corporation is promoting, it's easy to say, we don't think that you should be classified as a person. But how many times have we seen protests where people are talking about the need for corporations to have a social a social responsibility, or you need to have a better corporate conscience? Well, if you're not a person, you can't have a corporate conscience. Only a person, or like you said, John, a proxy person, can have that type of a conscience. And I don't think that's necessarily bad. I think that, there are corporations, like, obviously, I think Ben & Jerry's ice cream, if you look at any of their donations or the types of causes they promote and support, they have a very different type of corporate personhood than probably the Green family at Hobby Lobby does. But that's okay. That's the point of the First Amendment, is that you can choose as a tightly held corporation or as shareholders what type of corporate persona you want to have. So I think it just should be uniform and consistent across party lines.
John Gerardi, for you, listening to the oral arguments, what were some of the highlights for you?
I thought there were actually some funny moments when someone asked, Jonathan, you pointed that out to me, where someone asked if Justice Kennedy brought up whether we need to actually reevaluate the constitutionality of the whole Affordable Care Act to decide this, and then someone said, I believe we've already done that, Your Honor. So anyway. I thought what was interesting was the clear difference in concern between the liberal justices and the conservative justices. Liberal justices much more concerned about how corporate exercise of religion would affect third parties, and specifically, in this case, they were concerned with non-Christian employees of these companies who have, they believe under the Affordable Care Act, have a statutory right to contraceptive coverage, who now won't have it because Hobby Lobby is exercising this First Amendment right. And that's in contrast with the conservative justices, who are concerned with, is there any way then that a corporate entity can exercise some kind of, vindicate any kind of religious freedom right? I mean, does their, do their religious freedom concerns, do they simply have to accede to whatever the government demands them to do, even if it goes against the strongly held religious convictions of the shareholders? So, and this is really kind of the fault line, I think, between conservatives and liberals in discussing this issue. Who do we care about more here? Do we care about the potential impact on the shareholders of these businesses who being forced to do things against their religion, or do we care more about the third parties who might be in some way adversely affected by the exercise of religion on the part of the shareholders of these companies?
And I think it was key, because if you read through the oral arguments or listen to them, and I'm sure in the show notes we'll probably post the audio.
Up, yeah.
Oh, good. I'm excited, because it's a great opportunity, just as a side note, for any of the listeners to go hear what it's like inside the Supreme Court. Yeah. But both Justice Kennedy said and Justice Scalia said was that if the government can force you to do something against your religious beliefs in this area, they flat out asked, I think it was Justice Kennedy said, why can't the government fund abortion? And the Solicitor General for the United States got really nervous and said, well, that's not what this case is about. But he said, well, following your logic, isn't that exactly what this case is about? And I think that was really key for them to be able to show that even if and the Solicitor General kind of dismissed, well, we don't really think these are abortions.
Well, and that was his response, was to say, well, look, based on like the FDA guidelines and the way Obamacare is written, these aren't abortions. And yeah. I didn't feel like I want to hear any answer to that question. I thought that was a good question.
It was, and I was actually very encouraged. I don't know how you felt about this, John, but I know we're probably going to ask how we feel the justices are going to rule in the future. But I was encouraged that question came from Anthony Kennedy, because I think that bodes well for the case going the conservative direction.
Yeah, I think so. It seems Kennedy, clearly Kennedy was ready to throw out the entirety of the Affordable Care Act. So back in 2012 when it was upheld. Mm-hmm. So clearly he's no fan of these things. And it wouldn't surprise me if he decided to rule with, the kind of more, I guess, predictably conservative justices. There were some people who thought Chief Justice Roberts might try to, get away with it in some way to preserve it, but I don't know. I as far as predictions go, obviously, it's always a risky idea. But I think I think there's a good shot for Hobby Lobby to win this case.
The other case, John, I don't know if you've seen any commentary on this, but I was actually very kind of curious about the line of questioning that Justice Breyer took. And Justice Breyer is generally one of the more liberal justices, but he's also very thoughtful. He was not nearly as reflexively opposed as Justices Kagan, Sotomayor, and Ginsburg. He actually asked some very fair questions of both sides, and there were some people, I saw commentary that said they actually thought it could be a 6-3 decision with both Kennedy and Breyer voting with the conservative wing.
I want to go back real quick to what you were talking about, John. It seems like there's kind of this battling of is the rights of the employer versus the third-party employees. I was reading, articles this morning on, like NPR and stuff from people that are saying this is not about religious freedom. That's all it gets a scapegoat. It's not religious freedom. This is about, the rights of the poor employees who now they have a kind of this constitutional right to the contraceptives, and they're being trampled on. And if this case goes badly, then all hell is going to break loose. So just respond to kind of the concern. Maybe the best version of the argument from the other side. I think all of us could come up with some kind of way to make fun of another side's argument. What would be your response to the best, kind of most thoughtful concern of we're all opposed to discrimination. How would you respond to kind of the concern from the other side if Hobby Lobby wins this case?
Hobby Lobby's case is to say, okay, the Religious Freedom Restoration Act requires the government to show that this is a compelling state interest and that they've chosen the most narrowly tailored means of accomplishing that interest. And all that we're saying is that, no, this, whether or not you want to get into the question of whether it's a compelling state interest, it certainly isn't the most narrowly tailored way of accomplishing this while respecting the religious freedom of Hobby Lobby. So, there are 1.5 million ways that third parties who might be adversely affected by Hobby Lobby's decision can go about getting contraceptive coverage. There's all kinds of free programs this can be done. A new, different sort of government setup can be arranged to provide for this. There are any number of ways in which a less religiously, imposing setup could have been brought into play. So I think what's important here is to compare the burdens on each side. If you're a third party, like an employee who, because Hobby Lobby is exercising their freedom of religion not to provide these contraceptives, your harm is that you don't have access to contraceptives that realistically cost maybe $15, $20 a month. You can get it cheaper even. A lot of Planned Parenthood, other places provide it for free.
Unless they're wanting the IUD, which is more expensive.
Unless you want the IUD, which is more expensive. But still, there are lots of oral contraceptives, chemical contraceptives that are very effective that you can get without, too much cost to yourself. Meanwhile, these business owners, if they have sincere Christian beliefs and believe these things to be gravely immoral, they're sort of driven out of, being business owners. I mean, it's this sort of very severe infringement on their ability to operate as they've been operating. So if you're balancing the harms to each side, it's clearly there's a much bigger burden upon businesses. Furthermore, one of the main arguments for Hobby Lobby is that this mechanism for providing contraception is not narrowly tailored. This isn't the most narrowly tailored way the government could have done this. There are other ways this could have been done without harming the freedom of religion interests of businesses. So, I mean, there are a lot of different ways the government could have set this up. Other mechanisms to provide contraceptives, other programs to provide contraceptives without forcing businesses to pay for it. So those are kind of, I think, the responses you would make to the arguments that you presented.
Okay, I want to hear quick thoughts from both of you. I think it was Justice Sotomayor towards the beginning asking some, I thought, really good questions. Kind of like, what's the limit here on religious freedom? What if you had companies that wanted to deny vaccines,
blood transfusions, or like in my head, I was thinking, like, I mean, you had the parents not too long ago that I think they're in jail now because their second child died of cancer or something like that, because they were like against all medical treatment. So what if a company was like, we're opposed to like all like chemo and things like that? Like, at what point is there a line, a legitimate line, and it's just not abortifacients? Like, what are your quick views on that, like in 30 seconds or less, if you can? I think that's a very difficult question, and I think that was a fair and legitimate question by Justice Sotomayor. However, I think the thing that you have to point out is that already the HHS department is excluding all of those requirements on certain groups of people. For example, the Amish are not subject to Obamacare. Why do they get to be waived from every single requirement, including blood transfusions, including cancer, everything else? And yet the government is choosing to say, well, because you are part of a mainline evangelical or Catholic denomination, you don't get those same protections that the Amish people do. I mean, that seems very odd to me that they would allow for one religious group of people to be completely exempt, not just from the HHS contraception mandate, but from the entire law. Then at the same time saying, like John said, not trying to come up with a narrow, tailored requirement, but saying, no, you're going to be subject to all 3,000 pages of these regulations. That's my pushback, because I understand that there could be viewed a little bit of a slippery slope, but we're already there in some areas. And I think that you have to realize that at this point, they're not dealing with that. They're not dealing with the case of the Greens wanting to refuse blood transfusions or vaccines. Why don't we address first off the questions that's before us? I know pro-life people always get accused of trying to bring up a slippery slope argument whenever we're trying to, talk about whether it's a lot of different issues.
I think you just have to take each one. There are some slippery slope arguments that are fallacious and some that are not. You just have to analyze each one. Gerardi, anything to add to that?
Here's a crazy idea. Why not just let the market settle these kinds of questions? Maybe if people don't want to work for a company that doesn't provide these things, they don't have to. The market can work for some things, and this seems like it would be one of those things.
Okay, how do you think the court's going to rule?
I somehow, some way, I'm pessimistic. I think somehow Chief Justice Roberts is going to find some way to preserve this. I don't know.
Oh, you have a lower
I don't know.
view
I feel like every law professor, anytime I talk about like predicting what'll happen with like law professors or other lawyers, they all know what's going to happen and they all have differing views on what's going to happen. So I give up on trying to predict these things.
What's your prediction?
Well, I was going to ask John if he thinks there's any validity to the fact that there were twice as many amicus briefs filed in support of Hobby Lobby as opposed to support of the government.
I don't know that there's that much significance to it. It's not going to change. It's not going to change what Justice Breyer thinks about things.
Are you going to debate John Gerardi?
No. I am cautiously optimistic, especially after listening to the oral arguments and just hearing the tone. I heard an interview a couple of years ago with Justice Breyer, and I actually was very impressed with how scholarly and how, even though he votes against us, the conservatives probably 90% of the time. I don't know if you ever heard him interviewed, John, but he is a very intelligent man.
I
like to believe that all of these justices are very intelligent.
Yes, but I think.
Well, no, I mean, Josh, like Breyer is to the left what Scalia is to the right.
All right.
Like Breyer is like the lion, the leader. I mean, really, a lot of people just think Sotomayor is just like a disciple of his. I mean, he's. Not to say that all the other liberal justices are dumb or anything, but he clearly is kind of a cut above in terms of his leadership for the left on the court.
And the fact that he was speaking and the questions he was asking, it at least, again, I think all of us knew how the Obamacare case was going to be decided, like you said, John, until the morning that it was decided. And a lot of people I talked to knew how Prop 8 was going to be decided until it was decided. So I'm hesitant, but I'm going to cautiously say that it's going to be. I think it's going to be it's going to be overturned. But I think, John, to what you're saying, it may be that Chief Justice Roberts tries to narrow the scope very, very tightly, because it seems like that's what he's wanting to do these days, is try to make these rulings as narrowly tailored as possible to avoid setting a lot of precedent in the future.
Okay, final question for both of you. John Gerardi, you first. Where does the religious freedom road lead if Hobby Lobby does lose this case? How bad is it for religious freedom if Hobby Lobby loses?
I mean, it's pretty bad. It sort of winds up meaning that Christians are going to be driven out of, I think, a lot of industries. And I think it makes it makes it difficult. It'll just make it more difficult. We've seen all these cases of this actually has a big impact on the gay marriage front. These businesses in various states that are getting sued or getting charged because they don't want to provide a cake for a gay wedding or flowers for a gay wedding. That sort of thing is just going to increase, I think, unless we can find some way to say, no, corporations should have some way of vindicating their rights to religious freedom, because it's not really some robot money-making entity, the corporation. It's composed of people. So.
Right. Yeah, I agree. I think that the good news is, from some of the questions that were asked, specifically Scalia and even Kennedy on the issue of abortion, there seems to still be, in a sense, that Rubicon that the justices do not want to cross. They do not like the idea of direct public funding of abortion through forcing employers to pay for that. So I think in that sense, if they're able to draw a link directly in the future where, you've talked, I think, before on the show, and a lot of the listeners know how Obamacare does fund abortion in different ways. I think that if a case like that is brought in the future, it might still succeed. But I do also think that, like you said, John, this could potentially kind of be a dark day for religious freedom in general if it doesn't pass. And the key is, I think in a bigger sense, if the HHS department, if a secretary who is just serving at the pleasure of the president, an unelected, unaccountable member of the executive branch, can choose to overturn part of the Bill of Rights, I said on a radio show yesterday, why couldn't the HHS department say, well, you know what, you can own and bear arms, Second Amendment, but we're going to require that you pay a new stipend, $1,000 a year additional penalty or tax. On your insurance, because who knows, we need to have safety for people who might die or be hurt in accidental gun shootings. Or, if they start being able to regulate the basic freedoms that are in the Constitution like that, I think that is a potential slippery slope that opens up a real Pandora's box for the future of government overreach in a lot of other areas.
All right, fair enough. John Gerardi is associate at Egan, Flanagan & Cohen, as well as being a Notre Dame Law grad. It's always great to have you on the show. Jonathan Keller is executive director now of California Family Council. You can check out their website. They are doing a lot to protect religious freedom at californiafamily.org. If you have any comments for us, you can leave them below. If you go to prolifepodcast.net/193 for episode 193. And remember, you can always make a great impact in any conversation if you remember to ask good questions, listen to understand, and find genuine common ground when possible. That's our show. Now go talk to someone.
You've been watching Life Report, Pro-Life Talk, Real World Answers. Life Report is produced by Right to Life of Central California. Visit their website at fresnoprolife.org.